in the memo of appeal filed by the present appellants, the substantial question of law has not been formulated by the appellants. Though some grounds of the appeal were taken by the appellants in their memo of appeal, as if this is treating as if the appeal is a regular first appeal and not second appeal under section 100 of the Code of Civil Procedure. Stop. It is pertinent to mention herein that the section 100 within bracket 3 of the Code of Civil Procedure provides that in an appeal preferred under section 100, the memorandum of appeal shall precisely state the substantial question of law involved in the appeal. By not complying with the mandate of section 100 within bracket 3 of the Code of Civil Procedure, in this case, the present second appeal is not maintainable. Stop. However, not maintainable on that count only. Stop. However, as this is a very old appeal pending since 2010, it appears that this case was listed on several occasions. However, no substantial question of law was formulated by this court. It appears from order dated 29/5/2024 passed by this court that on that day the appellants proposed a set of substantial question of law to be formulated in this appeal. However, on perusal of the said draft substantial question of law proposed by the appellant, it was ordered that this court was prima facie of the opinion that same cannot be formulated as substantial question of law. The appellant was granted some more time for the ends of justice. So today also the learned counsel for the appellant has produced a sheet of paper containing draft substantial question of law. However, he fairly admits that these questions are the same set of substantial question of law which were proposed before the court on 29/5/2024. Stop. As there is already a finding of this court on 29/5/2024 that the substantial question of law proposed by the appellants cannot be formulated as substantial question of law. Hence, this court is not inclined to entertain the same set of substantial question of law again. Stop. In view of above, this court is of considered opinion that the petitioner has, that the appellant has not complied with the mandate of section 100 within bracket 3 of the CPC, as well as on perusal of the materials available on record. This court is also considered opinion that no substantial question of law is involved in this second appeal, and accordingly, the second appeal is dismissed. Let the records of the record
Record
Were
has
not-
not called
not-
for
not-
because not admitted.
not admitted, dismissed at the admission stage itself.
Deep level. Lordship, this CRP is against the order dated 4/5/22, page 108. Wherever the executing court has passed the order for execution of the decree in title appeal.
Which is the impugn order?
Impugn order is at page 108. Dated 4/5/22. 4/5/2022. Page 108.
What is this?
कितने में बीच में कुछ हो रही है कितने बीच में कुछ हो रही है
Well, stay was refused.
Yes.
Against that order, you have approached this
Yes.
court.
And the objection,
Under what provision you prayed for staying the execution of the decree?
47. Page 90.
102.
Huh?
102.
102.
Their application is Annexure 6, page 102, Lordship. Written objection under section 47(1) of CPC as amended up to date against execution of the decree passed in so-and-so title appeal by Civil Judge Bongaigaon, reversing the judgment and decree passed so-and-so by the learned Munsif number so-and-so. They are judgment debtors, Lordship.
You are judgment debtor.
I am decree holder.
What ground that petition was filed? What was the ground taken?
Section 47, order 1.
No, that is the provision. But
Provision.
Lordship will find page
section
100.
47, you are the judgment debtor. Can you file an application?
Judgment debtor.
I am the judge.
They are judgment debtors, Lordship.
Okay.
So
Okay.
they filed an application under section 47(1) before the executing court lordship to stay the execution. To stay the execution on the ground that as RSA is pending before the Honorable High Court till the disposal of the RSA, the execution proceeding may kindly be stayed, Lordship. Section 47 for a moment, Lordship.
Yes.
Questions to be determined by the court executing decree. Subsection 1. All questions arising between the parties to the suit in which the decree was passed or their representatives and relating to the execution, discharge or satisfaction of the decree shall be determined by the court executing the decree and not by a separate suit. So a judgment debtor can file under section 47 subsection 1. Accordingly, they have filed, but their ground is that, Lordship, para 4, page 103, para 4, Lordship. Entire facts of the case stated in para 4 and thereafter last 4-5 lines your lordship will find. In such view of the matter, the further proceeding of the instant execution proceeding is required to be stayed under the inherent jurisdiction of this honorable court so as to avoid multiplicity of suits cases. The answering judgment debtors crave the leave of this honorable court to file the copy
No,
of the stay.
In para 4, what ground you took? You took the ground that you have preferred a regular second appeal. That
That
is the
being-
only ground.
That being the only, not the only, the actual ground was that the executing court has gone beyond the judgment passed in title appeal, because as we have mentioned that there is no counterclaim made by the appellant in the title suit for any relief. But in the title appeal, while reversing the judgment of the title suit, has of his own, the court below, appellate court, given so many relief that comes in the order part of the judgment of the title appeal at page 68.
Now you tell me the brief. First brief me. How suit came, then what was you were the defendant in
I
this
was the
suit.
plaintiff in the title suit.
Or it was reversed in appeal.
Yes, my judgment, I got a decree,
You were plaintiff in the title suit. You
Yeah.
filed a suit for
declaration.
and only for declaration of right title and interest. Possession was
Possession was in our,
with you.
with you.
Okay.
So that-
Then in your suit, a counterclaim was filed by the defendant.
No,
No counterclaim
no
was there.
counterclaim was
Y-
filed,
Your suit was dismissed.
in the appeal,
In the trial court, your suit was decreed.
allowed, yes, decree.
What was the relief? Declaration of right title and interest.
Just look. What is it? Please look.
No, you have
Prayer.
you have to tell me your brief story so that I understand the case.
Which one?
But lordship, my question is whether section 47 petition
Lies-
is maintainable
lies or not.
in presence of regular second appeal. They have already challenged that matter before the Honorable High Court. Since 2001, the
It
RSA
is pending before.
pending before Honorable High Court. It was dismissed in the year 2012. Then miscase filed, restoration was
No,
allowed.
still let him make submission. What?
Lordship. So section 47 petition, lordship, they cannot hesitate any lordship objection before the executing
Huh?
court. Their only duty is to take stay order from Honorable High Court and then to submit before executing court. But on merit, how can section 47 petition can be filed before executing court when the regular second
No.
appeal they have already.
Before that, Mr. Soria, what is
Brief
the,
facts to Lordship.
what is the, you know your case
That was.
or you don't know your case?
I have to genuinely admit that since I came only yesterday, I was going to the case and right from the lordship a lot of time. This is titled, I may be taking more time than required, therefore, suit for declaration of title, injunction, title, suit for declaration of title it was.
No, have you gone through the brief or not?
Today I have tried to go to.
Ms. Chaudhary,
Lordship.
now there is no stay in this case.
No, lordship.
So if we defer it for 1 or 2 days, how you will be affected?
Lordship, executing court is not proceeding
Why?
only because lordship
is no
CRP is pending
In-
and in RSA one IA is pending.
We'll
Lordship,
make that observation
Lordship,
that
if your lordship
this
can-
pendency of this suit,
Lordship.
because the council is not ready.
Lordship.
Otherwise, it will take, I have not read the brief. It will take much more time. Let him come prepared. We will
Because-
make an observation that
Merit of the case at this relevant point is not necessary as because lordship, the RSA already dismissed 2 times.
no, I have
lordship.
understood.
Lordship.
When they have filed a regular second appeal where some substantial question of law has been
It
raised,
is already dismissed for default, lordship. It is not on board now, lordship.
or that has to be restored.
2012, once it was dismissed for default, then restored, then again they did not appear.
Now the
then-
question is whether the civil revision is maintainable or not,
Lordship,
or it has to be disposed of on merit.
on merit, they cannot challenge as because they have already challenged that matter by RSA.
But they
lordship.
have not made submission.
RSA is still, order for restoration is still pending.
No, if you are not ready, I am ready, I am prepared to give you time,
You oblige your.
but you
lordship.
have make submission.
Yes, my lord, I'll definitely submit that.
But then pendency of this civil revision petition
Let
would,
me go through this order, lordship. Earlier, 4126, they have preferred restoration application. In that application also, there is an order that
now 4126, in next item, there is a IA for restoration.
lordship, 4126 already disposed of. Now they have again filed restoration for that restoration application.
The restoration was also dismissed for
Dismissed,
default.
That was
Oh.
lordship, when it was first listed, the.
You are
applicant-
opposing that restoration also.
Yes, lordship.
Okay. Then when will you,
Your lordship,
when will you be ready?
my lord, 28th of August.
Okay,
Lordship,
to
may I
submit
kindly
it-
make a
I'll
clear
make
to-
observation, I'll
Lordship.
make observation.
Already there was an obligation.
You are making your appearance in this case
Lordship, in both the
because
cases.
notices are not yet issued.
In both the cases, lordship, I am appearing in
In
CRP, there was a
CRP,
condemnation, lordship. In condemnation, I have appeared.
in CRP, that is item number 2, item number 2. Heard Mr. S.K. Sohoria, learned counsel for the petitioner, also heard Ms. R. Chaudhary, who appears for
Respondent number 4.2 to 4.5.
respondent number 4.2 to 4, respondent number 4.5.
4.7 and 4.8.
And Mr. G. Bhardwaj appearing for respondent number 1 and 2. So, learned counsel for the petitioner has submitted that as he is not fully prepared with the case, he needs some time before making his submission in this case. The prayer is allowed. Let this case be listed again on 28 August 2024. Stop. It is however made clear that pendency of this civil revision petition before this court would not be treated as a bar for the executing court to proceed in title execution case number 4/2016 in its normal course. List this matter again on 28th.
Lordship, pendency of this CRP 74/2024 and RSA 89/. And
RSA is not pending.
lordship, interlocutory applications in RSA. They're taking benefit of that restoration application.
In
That is, number
interlocutory
form.
application number
2023, lordship.
now 67 is pending.
Yes, lordship. 67 is the restoration application for IA 4126.
And what is 4127?
4127 Lordship abatement, na condonation niki?
These are disposed of,
Lordship already all disposed of. 426, 27, 28 all disposed
all
of.
disposed of. So pending is only
67,
67.
2022.
In 67, you are ready,
Yes. Lordship.
or
Yes.
67 also on 28?
Delay of condonation. This is
67 of
20,
2023.
28. You are not ready.
actually, I came only yesterday. I was
Okay.
not going to record.
In 67 also heard Mr. S.K. Sohria, learned counsel for the applicant. Also heard Miss R. Chaudhary appearing for,
Here in this case, 4B to 4E, 4G and 4H.
appearing for 4, respondent number 4B to 4E, comma 4G and 4H, as well as Mr. G. Bhardwaj appearing for respondent number 1 and 2. Service report on perusal of the office note dated 29/7/2023. It appears that the notices sent to respondent number 3 and 5 have returned after due service. Stop. The notices issued to the aforesaid respondent, namely respondent number 4 and 3 and 5, are therefore held to be duly served on them. As regards respondent number 6A, 6B, 6C, 6D, 6E, after perusing the office note dated 29/7/23, the petitioner is directed to take fresh steps for issuance of note. You take fresh steps on petition, respondent number 6. Fresh steps on respondent number 6. 6 A, B, C, D, and E by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 28/8/2024.
Lordship may record in IS Civil 67 4F already died, Lordship.
It also appears from office note that respondent number 4A within bracket 4 within bracket small a and 4 within bracket small f have already expired. The applicant may take appropriate steps as regards the said respondents. Let this matter be listed again on 28/8/2024. It is hereby made clear that pendency of the instant interlocutory application in connection with regular second appeal number 89/20/2001 would not be treated as a bar for the executing court to proceed with the title execution case number 4/2016 in its normal course. List accordingly on 20.
Deeply obliged.
Cause list go series. 16 to 22.
May three, well, all these items are analogous arising out of the same accident.
Same accident.
Yes. Well, on my lord,
You are insurance company.
I'm for the insurance, one insurance company, Rajiv Goswami is for the other one. And owner of the scooter is appearing. On 5/12/2022, my lord, there was an order asked to take steps on the newly implemented respondent 2A and 2B.
How many appeals are there?
No, altogether, seven. Seven, no?
And respondents are same in all.
Set of respondent, only the claimants are different.
Okay. Then we can pass a common order
Yes,
today.
my lord, because my lord, in all the appeals, the respondent honor, my lord, the of the truck, the respond number 2 had expired. And we have substituted in by the legal heirs, my lord, they were put on record. And steps were taken and the, my lord, served notices are there flagged as X, flag X. And there was an order to that effect. And thereafter, we had taken steps, and, my lord, inadvertently, my lord,
Just a
on
minute, just
23/7.
just a minute. এইটো যেতিয়া common order মাৰিলে সাতটা 7 copy বলে 7 copy সব রেকর্ডত রাখিবি every record. Yes.
My lord, inadvertently, my lord, on 23/7/2024, my lord, maybe we had made a submission to take express steps on responding 2A and 2B. As because of that, my lord, this order was passed. But my lord, if you, my lord, sees the order dated 9/2/2024. The judicial order, 9/2/2024,
19-2.
9/2.
There is no 9-2 order. It is 19-2 order.
MSA appeal number
113. It is 19-2.
maybe, my lord. So it is noted as 9/2. Okay. AD card in respect of respondent are.
Because before the 19-2 order, the order was 512.
My lord. 5/12, yes.
Yes.
Where we were asked to take steps on respondent are 2A and 2B. Accordingly, steps were taken. And on 19/2, my lord, the AD cards were, my lord, found to be received as regards respondent 2A and 2B is concerned.
The service is complete also.
My lord, service was complete.
There is an order.
Yes, my lord. Thereafter, my lord, inadvertently, maybe we had made the wrong submission.
Okay,
was-
now what is the status of the service of?
My lord, all the respondents are served.
Okay,
And there was an order on 23/7/2024 asking us to, my lord, take first steps on respondent 2A and 2B.
not 23, 3/6/2024,
My lord is taking up MSC appeal 113 of 30.
113. 113. Okay,
3/6/2024, my lord. Yes.
3/6.
My lord.
So we can hold that service of notice on all the respondents are
Complete. As well
complete.
as the newly.
And whether records are there,
LCR were already there, my lord, because it was.
then
one
this is
thing
ready for hearing.
Yes,
It will go for hearing.
my lord.
Heard Mr. R.K. Bhatra, learned counsel for the appellants in all 7 cases common order. Learned counsel for the appellants for all the 7 appellants and all the 7 appeals. Stop. Also heard Mr. R. Goswami
For R5, not sir. Respondent
for
number five,
respondent number
immediate.
5.
Yes.
And Mr.
For respondent number 2.
M. Datta for respondent number 4. Learned counsel for the appellant has submitted that by order dated 2/6/2024,
3/6.
3/6/2024, this court directed the appellant to take fresh steps for issuance of notice to respondent number 2 within bracket small a and 2 within bracket small b. However, he submits that the notices issued to said respondents earlier were held to be duly served by order dated 19/2/2024. Stop. Which might not have been brought to the notice of the court when it passed order dated 3/6/2024. Stop. in view of the order dated 19/2/2024, wherein it has been held that the notices issued to respondent number 2 within bracket small a and 2 within bracket small b have been duly served, comma, it appears that notices to all the respondents in all the seven appeals in this batch of appeals is have been duly served. Stop. The else case record assigned 7, all 7. It appears that the concerned MSc cases from the tribunal have already been received by the registry of this court, and this batch of cases appeals are ready for hearing. Hence, list these appeals for hearing when in due course. It is 13 matter
It can be fixed anytime, my lord. I am ready.
within after 4 weeks on a date to be fixed by registry.
Obliged.
That's it. I am appealing for the Union of India, my lord. Here, my lord, what happened, my lord, the sole respondent already expired, my lord.
You're the appellant.
Appellant, my lord.
Hmm.
Therefore, I have paid for some time to take instruction, my lord, please instruction, my lord, from the department concerned, my lord.
Heard Mr. B. Sharma, learned Central Government Council appearing for this miss case is for
My lord, condonation.
condonation.
My lord. No, my lord, condonation, not my lord, restoration of the, my lord, please.
For the applicants. Learned counsel for the applicant has submitted that as the sole respondent has already expired and the appellant needs the applicant needs some more time to trace out the legal heirs of
My
the deceased sole respondents and prays for how much?
4 weeks. time.
4 weeks time for the same. The prayer is allowed. Let this matter be listed after 4 weeks.
Obliged.
None appears for the appellant. Applicant on call. Let this matter be listed again on. Uh-huh. 9. Again on. August 14th, 2024. None appears for the petitioner on call. Let this case be listed again on 16th August 2020.
So in this case, LCR has been received.
It's ready for hearing.
Yes, sir. One more thing, Manoj, if case was admitted on 18/1/19, Manoj, a substantive question law was framed, Manoj. One more substantive question of law that also need to be considered when I have framed. Last order, immediate question, last order, even last order. Last order, that was indicated.
Now, last order, what is it?
To frame another substantive question of law, Manoj. Manoj, by the order dated 18/1/19, Manoj, the appeal was admitted.
Yes.
The substantive question of law was framed. And then the last order, Manoj, that's what another. An order. Maybe then, Manoj, this is another substantive question of law that maybe.
No, substantial question of law you have to mention in the memo of appeal.
Manoj, I have already mentioned that it's there.
That was not considered.
Uh, that
Then-
is allowed.
Because once substantial question of law has been formulated before admitting the appeal. If
Manoj,
required, we will,
It is there, that part is there, that issue.
okay, if
Paragraph 5. For one
if
line,
required, when the matter is taken up for hearing,
Manoj,
you may
Yes.
raise that, we will formulate it then and there.
Manoj. In the grounds I have stated.
Okay, the services, where is the substantial? Point? Only one is
One is there. And I've also raised many grounds.
notice on the respondent is complete.
Yes, Manoj.
Heard Mr.
M. Smith.
M. Smith, learned counsel for the appellant, and also heard Mr. K. Kolita, learned counsel appearing for respondent number 1. The trial court record have already been received. NCRIC. And this case is ready for hearing. The registry is directed to list this matter for hearing after 4 weeks on a date to be fixed by it.
Hello.
Lordship, as per office noted dated 5/8/2024, AD card has been served upon respondent number 4 and 5. The Lordship service has been completed.
CRPIO.
Yes, Lordship.
Heard Miss
K. Sharma.
K. Sharma, learned counsel for the appellant. None has appeared for the respondents. On perusal of the office note dated 5/8/2024, it appears that the AD card issued to respondent number 4 and 5, along with the notices sent to them by registered post with AD, have returned back. in view of the same, it is hereby held that the notices issued to respondent number 4 and 5 are deemed to be duly served. Let this case be listed for admission hearing after 1 week, on a date to be fixed by registry.
May it please, your lordship, with regard to item number 25, as in a different code, your lordship, my name may be recorded, your lordship. I'm extremely sorry for the inconvenience, your lordship.
Item number,
25, your lordship.
you are for?
And for the, some of the respondents, I provide the now numbers of the respondents to the court master, your lordship. 7A, 8B,
Item number 25. Mr.
A Das. your
A.
lordship.
Das appears for
I provide the responding numbers, your lordship. There are some numbers, your
respondent
lordship.
number.
7A. I provide.
You will,
Much obliged, your lordship. Thank you, lordship. Lordship, I beg to interpret you. Lordship, I have a serious problem. Item number 39 and 41, in fact, all of us will have this problem. And there is already a waterlogging problem in my area. So that day I got stuck for 6 hours.
now what is your prayer?
I say, can this, my matters be postponed? Lordship?
Yes.
39 and 40 is the order matters.
Okay.
39 and 44. Lordship.
39 and 40 on request from
44,
Mr.
yes.
44 on request from Mr. R. Goswami. These matters are adjourned for today. Let it be listed again after a week
Yes,
on a date to be fixed by registry.
32.
32 also.
Item 32.
Item 32 on request of,
32, my lord, I am my lord.
Oh.
he is praying for adjournment. You have any objection?
Oh,
It will go for hearing, my lord.
32.
Hearing may fix.
Heard Mr. K. Bhuya, learned counsel for the appellant. Also heard Mr. A. Alam, learned counsel for the respondent. What for this IAs are
I
there?
am lordship for condemnation of delay.
Delay for?
To set aside the abatement. When the appeal was dismissed, but prior to that, the sole respondent demise.
No,
That
no.
was not brought on record.
Now you are mentioning for adjournment.
It should be fixed for hearing, my lord. Hearing on the petition.
Regarding condemnation, my lord,
In orders column, orders itself, it can be heard.
All right, my lord. Then,
We are just postponing it
yeah,
today is
on,
possible.
on request of
And there is a
Both
learned
sides.
counsel for both the sides.
both the sides.
Let this matter be listed after a week on a date fixed by registry.
and
Registry will fix the date.
interim, my lord, so far interim order is there.
Interim shall continue till next week.
I love that. After 2 weeks,
After 2 weeks.
I have some difficulties. Right, the time, yes.
None appears for the applicant on call. On perusal of record, it appears that on last several occasions, no one has appeared for the applicant. This interlocutory application is therefore dismissed for default.
May it please your lordship. Lordship, in this case, the LCR has been received. And as per last order dated 19/6/2024, lordship, it is submitted that the issue which is involved in this case, my lord, has been resolved by recent judgment of a coordinate bench. So lordship, I would request you, lordship, kindly a date may be fixed for urgent, yes, early hearing, because it's already covered with the decision of the
This case is ready for hearing. Heard Miss
I'm Sharma.
M. Sharma, learned counsel for the appellant. Also heard Mr. H. Gupta, learned central government counsel. The counsel for both the sides have submitted that this case is ready for hearing and have prayed for listing it on an early date. Considering the submissions made by learned counsel for both the sides, let this matter be listed for hearing.
Lordship, can it be fixed on 22nd of August? It's a hearing day, Lordship. After 2 weeks,
On after 2 weeks, on a date,
second,
on 22nd of August.
deeply obliged.
None appears for the parties. None appears for the petitioner on call. On perusal of the record, it appears that on last 2 occasions also, nobody had appeared for the petitioner on call. This revision petition is therefore dismissed on for default.
May I please, Lordship? Lordship, service is complete on respondent 1, 2, and 4, my lord. Already served, my lord. And await service on respondent number 3 and 5, my lord. We have taken service of notice to Dusty service, my lord, on 1/3/24, my lord. But service is awaiting, my lord,
You have taken steps for,
on 2, 3, and 5, my lord, to duly served, my lord.
through Dusty service.
Yes, my lord. 2
Yes.
is represented by Mr. P. Sekia, my lord. Already name is there, my lord.
Okay. Third, Miss L. Sharma, learned counsel for the appellant. None has appeared for respondent side. You have taken steps for Dusty service on 2, 3, and 5.
Yes, my lord. 2
And,
represented by Mr. P. Sekia, my lord. Already written there, my lord, in the record, my lord.
and 3 and 5,
3 and 5, my lord, awaited, my lord. Dusty service. not
you
returned yet, my
submit
lord.
a,
No, my lord. 3 and 5.
you submit an affidavit if,
Yes.
what happened to Dusty service?
My lord, they have awaited, my lord, not to complete, my lord.
But Dusty service, it is
Not
you,
served, my lord, yet,
it
my
is
lord.
you who will be serving the notice on the respondent. The appellant himself will be serving the notice on the respondent.
Yes, my lord.
So you know whether it is served or not.
Yes, my lord.
So you have to tell,
Again,
With-
my lord.
you,
Yeah.
you want to take fresh steps.
Okay, my lord.
Because Dusty service is personal service.
Yes, my lord.
You know whether you have served
Oh,
or not,
Information is being.
or that you have not been informed.
Yes.
Why? Appellant is insurance company.
Yes, my lord.
You see, okay. Learned counsel for the appellant has submitted that though the appellant has taken steps for issuance of notice on respondent number 2, 3, and 5
On
by Dusty mode, however, she needs some time to seek instructions regarding fate of the said notices. Stop. The prayer is allowed. Let this matter be listed again after 2 weeks.
oblige.
One of the petitioner has filed an appeal against the order of decree of divorce passed by the learned district judge Tinsukia on the ground that same is a nullity under section 19. There is some delay also. I filed an application for condonation of delay.
Well, the council is unable to contact the petitioner for seeking necessary instructions regarding the correct address of the sole respondent. and prays for some more time for doing so. The prayer is allowed. The petitioner is allowed 4 weeks time. 2 weeks time.
Where he stays in Uttar Pradesh, so.
Okay, 4 weeks times for doing so. The interim order shall continue till next day, at least after 4 weeks.
Mr. Your Lordship. My lord, as per order of Lojima Court Lordship 2824 Lordship, this is notice upon respond number 2 has been delivered Lordship. And respond number 1 has already appeared Lordship. And Lord Court Accord has already been received. Matter may be fixed for you.
Heard Miss M.
Chaudhary.
Chaudhary, learned counsel for the appellant. Also heard Mr.
Yes, okay.
S. Hawk, appearing for
This was
Respond.
number 1,
respondent number 1.
claimant.
On perusal of the order of the past order dated 2/8/2024 passed by Learned Lajima Court, it appears that notice in respect of respondent number 2 has been duly served.
Delivered. Delivered. yes.
Stop.
Delivered.
The trial court record has already been received by the registry of this case, this court, and this case is ready for hearing. Hence, let this matter be listed for hearing after in user
October Lordship, the month.
after 3 months.
Lordship.
After 3 months on a date to be fixed by registry.
Lordship. Must oblige Lordship.
Obliged.
May I please, Your Lordship? Lordship, I am for the respondent, Your Lordship. And with this matter become infructuous, Your Lordship,
You are for respondent,
respondent. Yeah.
who is for the, how it has become infructuous?
The divorce petition which was pending before the district judge Hailakandi, which was decided way back in 35/23, Your Lordship.
It was decided
Yes,
in your favor.
yeah, in my favor, Your Lordship.
It has become infructuous. What is your submission?
The petition is already decided.
Now there is nothing pending.
No, Your
She can only
as per my instruction.
file an appeal.
Yes.
The divorce suit has been decided. Heard, you have any submission? No.
No, Lordship, but this last occasion order dated, Lordship, they have not appeared, so kindly see the 17/5/2023, Lordship. Yes, okay.
Okay, now today they have appeared. You don't have instruction.
No, Lordship, I have no instruction, that's.
What is to be done? Do you concede to his submission? Or you will take your own instruction?
Instruction, Lordship.
Let her take instructions.
Okay.
Heard Miss M. Rongmei, learned counsel for the petitioner. Also heard Mr.
R.M. Mazumdar.
R.A. Majumdar, learned counsel for the sole respondent, who submits that this transfer application has become infructuous due to the fact that the divorce suit, that is PS within bracket D case number 49/2021, which the petitioner has prayed for transfer, which is the subject matter of this transfer petition, has already been disposed of by order dated
3/5/23.
3/5/23,
30, Your Lordship. 35/23.
35/2023
Yes,
in favor of the
respond.
respondent. Stop. Stop. However, Ms. R. Rongmei, learned counsel for the petitioner, comma, in view of the submissions made by learned counsel for the respondent, comma, has prayed for some time for seeking necessary instructions from the petitioner. The prayer is allowed. How much time will it take?
2 weeks time.
let this matter be listed again on after 2 weeks on a date to be fixed by registry.
Abhilash.
As per office note, service upon respondent number 2 is not yet completed, Your Lordship. I may be allowed to take fresh step, Your Lordship. It can be our knowledge that respondent number 2 has shifted to Bihar recently.
You have his new address.
Yes, Your Lordship.
How, Mr.
S. Diffusa appearing on behalf of D. Chaudhary.
S. Diffusa appearing on behalf of Mr. D. Chaudhary, learned counsel for the petitioner. Also heard Miss
M. Bhattacharjee,
M. Bhattacharjee.
on behalf of respondent number 1,
appearing-
except all respondents except 2.
Appearing on behalf of respondent number 1, 3, 2, 3, 4, 5, 6, 7, and 8. Stop. Learned counsel for the petitioner has submitted that the petitioner has been informed that the respondent number 2 has shifted to Bihar, and therefore he prays for some more time for collecting the correct address, collecting the new address of the respondent number 2, and to take fresh steps for issuance of notice on the said respondent. The prayer is allowed. The petitioner shall take steps for issuance of notice on respondent number 2 at his new address within a week from the date of this order, returnable after 4 weeks.
And your lordship, they
Your
have
Lordship,
filed
file
one
IA,
IA.
Your Lordship. It's for substitution, Your Lordship. Yes.
Let the, go to let this matter be listed after 4 weeks. The-
Respondent number 1.1, Arju Begum expired, Your Lordship.
Who expired?
Respondent number 1.1, Arju Begum.
Then whom you want to substitute?
Her legal heads, Your Lordship.
What is the name?
Saidul Rahman husband, Iqbal.
Where have you mentioned?
In page number 6, Your Lordship.
You have no objection.
Kindly
you-
issue the notice.
You may appear.
No, your lordship.
Since she's been appearing for respondent number 1.1.
Because legal heirs name and
They have not engaged you. Okay.
so kindly issue the notice, and I have not received any copy.
No, the substitution we will allow.
If it is beyond the time, then
It's within a time period.
When she died
She died on 19/5/2024.
and when this application is filed,
On 16/7/2024.
within how much period? Within 90 days.
Within 60 days, within 90 days. Your Lordship.
kindly issue the notice, your lordship.
No, when they have filed a substitution petition and you are the remaining, you are representing remaining respondent.
I am the responding, I am the appearing on respondent number 1.
1/1.
But
No,
What
we will substitute the new respondents and issue notice to new respondents. We will dispose of this IA. Heard, Mr.
S. Diffusa.
S. Diffusa,
Appearing on-
learned counsel for the applicant. Also heard Miss
M. Bhattacharjee.
M.
Bhattacharjee.
Bhattacharjee, learned counsel for the respondent number 1 to 8, except respondent number 2. This application under Order 22, Rule 4 of the Code of Civil Procedure has been filed by the petitioner for substituting the legal representative of deceased respondent number 1.1, namely Musammat Arzu Begum, who had expired on which date?
19/5/2024.
On 19/5/2024. Learned counsel for the applicant has submitted that this application for substitution has been filed within the period of limitation, and therefore the legal representative of the deceased respondent, namely number 1 Syed Sajidul Rahman, number 2 Syed Iqbal Masoom Rahman, Iqbal alias Masoom Rahman, and number 3 Syed Muklesh Rahman may be allowed to substitute it in place of deceased respondent. Considering the submissions made by learned counsel, as well as considering from where we come to know that she has died. You have informed her.
Your Honor, on 19/7/24, I have filed one petition under Order
Informing the
22
court.
10A. to
Informing
inform
the
it,
court.
But the petition has not been tagged.
Okay. So under Order 22, Rule 10A, you have informed the court, so they came to know. Okay. Considering the submissions made by learned counsel for the parties as well as materials available on record, this application is allowed. The legal heirs of the deceased respondents named herein above are allowed to be substituted as respondent number 1.1 within bracket A, 1.1B and 1.1C respectively. The registry shall make necessary correction in the connected CRPIO. Correction in the connected CRPIO number 257/2022 by including the names of the deceased respondent in the cause title and list the same again after a period of 1 week. After the listing, we will issue notice. After correction, it will be again listed. Then we will issue notice. List accordingly.
God bless you, Lordship.
What is
May it please, your Lord.
it? Yes.
My Lordship. With regard to section 50, my Lord,
What was the case?
before, my Lordship,
Forgot everything.
my Lord, this is an NDPS Act, my Lord, 75-year-old man, he is behind the bars for last 14 months. My Lord,
Two
the
persons
two
with-
persons, they have,
One with a sling bag
Sling
and
bag
one with
and
gamusa
another one, gamusa in the
waist.
waist. My Lord.
Okay.
So recovery of opium, offense is 18B NDPS Act, my Lord.
Yes, you found out the case.
My Lordship, my submission was with regard to section 42, my Lord. In the cross part, at the very inception, when the defense side has put a question that whether any authorization has been obtained, my Lord. So he has categorically admitted that he was not authorized to, my Lord,
even to go to the place of occurrence. But that is the cross. In the very inception, it is the admission part, my lord. Twice, my lord, his statement for chief has been recorded, my lord. Then he was cross-examined. And in the cross part, my lord, he has stated, my lord, I was not given any written authority letter by the superior officer to go to the place of occurrence. And my lord, on the last page, my lord, in the cross,
Yes,
he has, my lord, stated that at the time of incident, I was a probationary officer.
but he was a sub-inspector of police.
Sub-inspector, probationary officer, my lord.
Okay. How it affects your case?
My lord, my case is that he was not authorized to conduct the search and seizure, my lord. Because, my lord, though in the FIR, the PW1, the informant has stated that the department is empowered. But, my lord, while examining him on chief, my lord, he has not stated, my lord, anything with regard to, my lord, the authorization part. Rather, during the cross-examination, he has admitted that he was not authorized. That is with regard to 42, my lord. Now, my lord, another, my lord, provision that is 50. If my lordship permits me, may I, my lord, point out some, my lord, relevant materials from the petition as well as from the evidence, my lord. That is page 16, my lord, of my petition. Page 16. This is the FIR, my lord, third para, fifth line, my lord. Before that, my lord, we reached the Gargaon village road along with the 3 witnesses and found the persons, namely Ranjit Deori and Ganesh Chandra Deori. So notice under section 50 of NDPS Act was given to him for body search. But I believe that the suspect would part with possession of NDPS substances if search to be conducted in front of a magistrate or gazetted officer. So I have decided not to take them to the magistrate or a gazetted officer, and instead I made search of his body as per section 50 subclause 5 of NDPS Act following due procedure. But
What is 55?
so NDPS Act. Yeah.
Very good.
Yes.
'55, my lord, when an officer duly authorized under section 42 has reason to believe that it is impossible to take the person to be searched to the nearest gazetted officer or magistrate without the possibility of the person to be searched parting with possession of any narcotics, drug or psychotropic substances or controlled substances or article or document, he may, instead of taking such person to the nearest gazetted officer or magistrate, proceed to search the person as provided under section 100. Chance recovery, my lord, 50 subclause 5 is basically, my lord, adhered to by the, my lord, investigating agency when a case of chance recovery is there, my lord. But this is if at the very inception, my lord,
Yes.
in the first para itself, my lord, they have, it is the case of the prosecution that, my lord, this is to inform you that reliable information was received from a source by me at about 2:45 PM today, 6 June 2023, regarding consumption and sale of psychotropic substances by Ranjit Deori. So, my lord, this is not a case of chance recovery wherein, my lord, the investigating officer, my lord, the officer who has conducted the search and seizure, my lord, would have, my lord, the provision under section 50 subclause 5 is required. Prior information was already there, my lord, and on the basis of the prior information, my lord, they proceeded to the place of occurrence, which is, my lord, about 50 minutes, my lord, away from the police station, and there, my lord, they have found the, my lord, 2 accused persons. So, first, at the very inception, my lord, it was the duty of the, my lord, investigating officer or the, my lord, the officer who had conducted the search and seizure to write down this information and, my lord, then proceed, my lord. But that is, my lord, during the trial, my lord, it may not be much of relevance in this during the bail, my lord. But my lord, so far as provision of section 50 compliance is concerned, my lord, it is mandatory, my lord, because this is not a case of chance recovery, my lord.
Okay.
Now, my lord, I'm relying on some judgments, my lord, of different high courts. This is, my lord, 2009-16 SCC 496, Raju Premji, para 11.
What it says?
2009-16 SSC 496, Raju Premji versus Customs, para 11. The Act provides for stringent punishment, where a statute confers drastic power and provides for stringent penal provisions, including the matter relating to grant of bail. The conditions precedent thereof must be scrupulously complied with.
Yes.
Then, my lord, 2022 one crimes, High Court 270.
What is there?
Para 9, my lord. The married, my lord.
Yes.
Honorable the Kerala High Court in Lebibul Mubarak versus State of Kerala 2018 3 KLT 363 held that non-compliance with the mandatory provision of section 50 would vitiate a conviction for illegal possession of contraband, and in such circumstances it would be a failure of justice to compel the applicant to remain in custody till the conclusion of the trial. Now, my lord, para 10, married, my lord.
Yes.
In an instant case, no doubt, notice under section 50 of the NDPS Act mentions the petitioner having been apprised of his rights, but the said notice is absolutely silent as to what rights were apprised to the petitioner, as also whether he was apprised of his right under section 50 NDPS Act to be searched in presence of a magistrate or a gazetted officer. The said notice merely mentions the petitioner having been informed of his rights, as also the option, if he so desired, to get his search conducted by magistrate or gazetted officer. To my mind, merely informing the petitioner that he had rights under the NDPS Act without specifying what rights the petitioner had under the NDPS Act would not constitute compliance with the mandatory requirements under section 50, subsection 1 NDPS Act. The mandatory requirement under section 51 NDPS Act not having been complied with, and a punishment provided for an offense under the NDPS Act being very stringent, failure to comply with section 50 NDPS Act renders the recovery of the illicit article suspect. It is also not the stand of the prosecution that the petitioner is a person with criminal antecedents or that he is involved in similar offenses earlier. Since the requirement under the section 50 NDPS Act is not merely a technical breach and the petitioner is not involved in any other case under the NDPS, therefore, in the circumstances, in view of the position as noted above, for the limited purpose of the instant petition, it can safely be recorded that this court is satisfied that there are reasonable grounds to believe that the petitioner is not guilty of such offense and that he is likely to commit any such offense while on bail. Then, my lord, fourth line, para 11, so and so is ordered to be released on regular bail. Now, my lord, another order, my lord, report, Raghu versus Rahul Rajput Thakur versus State of Odisha. My lord, the citation is 2023 0 Criminal Law Journal 487. Para 21, my lord. May I read now?
Yes.
To release the petitioner on bail, this court has to examine whether the twin conditions as prescribed under section 37 of the NDPS Act is complied with before any order is passed to enlarge the petitioner on regular bail. So far, the twin conditions prescribed in section 37 of the NDPS Act is concerned. The first condition, that is the prosecutor must be given opportunity at the time of hearing of the application for bail, is duly complied with in the present case. So far as the second condition, that this court is satisfied that there are reasonable grounds for believing that the accused petitioner is not guilty of such offense and that he is likely to commit such offense while on bail is concerned. Due to non-compliance of section 50 of NDPS Act, this court is of the prima facie opinion that there exists a reasonable ground to hold that the petitioner prima facie is not guilty due to non-compliance of mandatory provision of section 50 and the petitioner is likely to be acquitted by the trial court if there are no other materials evidence brought on record in course of trial. Para 22. My lordship.
Yes.
Para 22. The next question that falls for consideration is whether the fact of compliance oblique non-compliance of mandatory provisions like section 42 and 50 of the NDPS Act could be examined by the court while considering the bail application. There is no doubt that offense to consider the compliance, non-compliance of mandatory provision like section 42-50 of the NDPS Act, the court is required to look into the facts and materials collected by the prosecution or the records maintained by the prosecution in course of search and seizure and investigation. Further, to come to such a conclusion, the court is required to scan the evidence and examine the record. Therefore, this court is of the considered view that if the non-compliance of mandatory provision of section 42 and 50 of the NDPS Act is clear and self-explanatory from a bare reading of the FIR/prosecution report, and the prosecution is not in a position to explain that the same has been substantially complied with, in such eventuality, such non-compliance of section 42 and 50 of the NDPS Act could be considered and should be taken as a ground to enlarge the petitioner on bail. Following the Constitution Bench judgment, supra, on non-compliance with mandatory provisions like section 42 and 50 of the NDPS Act would vitiate the entire search, seizure, and recovery. Therefore, if there is a possibility that the accused is likely to be acquitted for non-compliance of mandatory provisions like section 42 and 50 of the NDPS Act, allowing the petitioner to continue in custody without would not serve the ends of justice. Therefore, this court has no hesitation to hold that if the prima facie from record oblique FIR, it can be established that section 42 and 50 of the NDPS Act, which is mandatory in nature, has not been complied with. The court considers the bail application can always use the same as ground to enlarge the petitioner on bail. And in such event, the power contained in section 37 of the NDPS Act would not be attracted to the facts of the case. Now, my lord, another judgment, my lord, very limited point, my lord. It is citation is 2023 3 JCC 1497. Para 64, my lord. Third last page, para 64.
Yes.
May I read me?
Yes.
Therefore, in my considered opinion, the basic requirement of section 50 of the NDPS Act not having been complied with in the instant case, in view of which I am satisfied rigors of section 37 would not be an obstacle in the release of the applicant. And my lord, before that, my lord, the entire section 50 and 42 has been discussed, my lord. Now, my lord, one more judgment, my lord, that is Honorable Apex Court, my lord. Director of Revenue. No evidence. Director of Revenue. Well, 2008 2 SCC 370. Director of Revenue and another versus Mohammed Nisar Holia. Very limited, my lord, para 17.
Yes.
Fifth line, my lord. From the top. The statute mandates that the prosecution must prove compliance of the said provisions. If no evidence is led by the prosecution, the court will be entitled to draw the presumption that the procedure had not been complied with. So in the evidence of PW1, it is with regard to, my lord,
So every procedure was followed. For that, you have to adduce evidence
my lord,
that,
as
that-
per the apex court judgment, my lord.
okay.
Because, my lord,
Otherwise, there will be a presumption that the said procedure was not followed, for which there is no evidence.
my lordship.
Okay. Okay.
So now, my lord, if my lordship for a moment peruse. This is page 16 of my petition, my lord.
Yes.
Page 16, my lord. Third para.
Yes.
We reached at the Gargaon Village Road along with 3 witnesses and found the persons, namely Ranjit Deori and Ganesh Chandra Deori. So notice under section 50 of the NDPS Act was given to him for body search, but I believe that the suspect with part with possession NDPS Act. So if search to be conducted in front of a magistrate or gazetted officer, so I have decided not to take them to the magistrate or a gazetted officer. So he has decided not to take them, my lord.
Okay.
In the, my lord, thereafter,
What was the requirement otherwise? Requirement was
requirement
if he
was
feels that it was impossible to
that is
take
chance
him-
recovery, my lord.
take him to magistrate.
My lordship. If, my lord, if it would have been a chance recovery, then, my lord, the compliance would not have been mandatory. But this is a case of prior intimation. So recording of the information followed by, my lord, compliance of section 42 and 50 is mandatory, my lord. These are very harsh, my lord, under the Act, my lord. And these are the only, my lord, limited benefits the accused have, my lord. Now, if my lordship may kindly come to the evidence that has been given by the PW1.
Yes.
PW1, my lord.
How many witnesses are there?
One witness, my lord.
Total listed witness?
Total, my lord, there are 6, 10, 6 witnesses, my lord.
Only one examined.
One examined, my lord. 14 months. Main witness is, my lord, PW1, my lord. He is the informant and substantive part of the investigation he has done, my lord. So PW1, third page, my lord.
Yes.
Third page, my lord. Second line, I'm placing reliance on me. Therefore, I searched the body of Ganesh Chandra Deori, but nothing was found from his possession. The sling bag carried by Ganesh Chandra Deori was searched by me, wherefrom I recovered kani kept inside a black color polythene bag. Then I searched the person of Ranjit Deori and recovered one Oppo mobile handset from his person. I found one knot on the gamusa worn by the accused Ranjit Deori on his waist, and therefrom I recovered some amount of kani. Then second page, my lord.
Yes.
Subsequent page, my lord. 12th line.
Next page.
Next page, my lord. 12th line.
Yes.
I gave intimation to the SP Sodia regarding body search of the accused persons without the presence of any gazetted officer and magistrate. This is examination in chief, my lord. This has come, not cross examination. Then in cross-examination, my lordship will find first line, my lord, I have already placed, my lord. I was not given any authority letter by the superior officer to go to the place of occurrence. But he accept this, my lord. He has stated nothing about any authority, my lord, of being, my lord, to conduct the search and seizure. Cross also, my lord, if my lordship permits me, the second part, my lord. I have not mentioned in the notice the place and time where and when I served notice under section 50 of NDPS Act to the accused person.
Okay.
Then, my lord, cross-examination done for Ranjit Deori, my lord. Relevant part only I am reading, my lord. It is not mentioned in MCD that before issuing notice under section 50 of NDPS Act, I informed the accused of their legal rights. Cross-examination, my lord. Then again, my lord, subsequently he has stated, I have not mentioned in the MCD and in the notice issued to the accused under section 50 of NDPS Act that I read over the contents of the same to the accused in Assamese language. And lastly, my lord, second last line, he said, I'm a probationary officer, my lord. And so far as witnesses also concerned, they have not been, my lord, independent witnesses. They were not recorded from the locality. While going to the place of occurrence, my lord, in the road, they have taken some witnesses along with them, my lord. That has also come, my lord, in the evidence, my lord. That is my limited submission.
Yes, Mr. Bush.
Madam. Madam, in this regard, I'd like to submit regarding the section 42, why the compliance of section. I'm not taking so much time, lordship. That is from the page 16 of the FIR. That is the reliable information was received from a source by at about 2:45 p.m. at the day hour, lordship. There is a 2:45 p.m. And as because it is a 2:45 p.m., it is an admitted fact that there is a in the day hour as without warrant under section 40, without authority letter, in the 42, he may search. So he went there, lordship, in the CD available part. I have flag mark 3 note, this is like only 3 flag marks, lordship, where at what time they went out and at what time they recovered the contraband and came on that part. In the statement of the PW1, lordship, in the cross part, when it is cross-examined, he said that up to 4:45 p.m., the contraband was recovered. Only the part is that he said that 50 minutes is required. That is also flag marked, lordship. 50 minutes required from that place of occurrence to the police station. That is required. And he said that at 7 p.m., if I am not wrong, maybe time maybe there may be mistake in my part, lordship. He reached there. That part is there. And after going through that particular, that is the entry in the CD, lordship, I found that as because it is the 6th of 2023 in the month of June, at about 4:30 or 4:45, if they have done this, and by 6:25, they came to the police station, it is within the day hour, before sunset, lordship. If it is before sunset, lordship, then the questions of the proviso 2 of the section 42 will not come. Now, my lord, regarding the violation of section 50, lordship.
No, otherwise, if it is before sunset.
Yes.
During morning from sunrise to sunset.
Yes, lordship.
Then who can search and seize? Anybody can search and seize?
No, lordship. It is because he is an SI.
Then.
And there is no, because it is stated who can search, lordship.
He has to be authorized by a general or special order.
No, lordship. If it is after sunset, then it is required. Otherwise, lordship, it is stated that any such officer, being an officer superior to the rank of rank to a peon, sepoy, or constable.
Any such means what?
Those who are not gazetted officer.
Those who are not gazetted.
Not gazetted officer, and 42 says the power of entry, search, seizure, and arrest without warrant or authorization. So here in this case, it is a that is the matter of section 42, because there is no authorization letter from the superior authority under 41. Under section 41. So it is a matter of section 42, my lord.
Any such officer means being an officer superior in so and so.
Because SI is superior to that rank, my lord.
So and so. As is
Empowered.
empowered.
As-
This line, as is empowered.
As empowered by government notification, lord.
General or special order.
Where is that notification?
That-
Whether SI has been empowered.
Then I have to take that notification, lordship.
There is a
Otherwise,
process.
that notification is available. What I know is that
It
because
is,
one SI is empowered.
it is, yes, it is available in net.
Right now that I cannot say, but I can obtain that,
So
lordship. I can obtain that. And I can
your
place before the-
submission is that as
Lord-
because he
lordship,
was
yes.
SI.
Yes,
irrespective
he is
of
an SI.
fact,
He may be a provisionary officer. That
probationary
is,
or
that is a
that
different
is a
thing, but he is an SI. And
Therefore,
he is
his-
empowered by as per the government notification. Only the question is that when he went out, whether the search or seizure is made within the sunrise, from the sunrise to the sunset or after sunset, that is in
If
question.
it is within, before sunset,
Before,
authorization or warrant is not necessary.
not required because as he is empowered by a general order, general
That
notification.
general order.
General,
Now,
general
while adducing evidence before trial court,
lordship.
the prosecution side has a duty to even exhibit that general order,
Lordship,
that there is a compliance of section 42.
lordship,
Suppose that is not exhibited,
lordship,
then by virtue of this Supreme Court judgment which he has cited,
lordship.
that every procedure has been followed, for that some evidence has to be adduced.
Hmm.
That this evidence is showing that procedure has been followed. This general notification ought to have been exhibited.
Hmm.
Okay, so your submission is that authorization is not necessary as because has been, because of the fact he is an SI.
He is an SI. He is
he
empowered by the
empowered,
government
general
notification,
Okay,
and the search and seizure is made within the day before sunset.
before sunset.
Before sunset.
Okay, as regards section 50.
As regard section 50, lordship, that is the section 50 is about the condition under which search of persons shall be conducted. Now, under the subsection 5, lordship, he clearly states in the CD also it is stated, lordship. I have flag marked that part also.
Yeah,
In vernacular language, he has stated why that is the 55. He didn't take him to
he
the.
thinks.
Yes, he mentioned in the CD part, lordship.
What he says?
He says, lordship, that because he may go away, lordship, exact line I forgot, but I have flag marked that part. And only because of that, under section 100 of CRPC.
That mentioning of that reason is necessary.
Yes, lordship. That is lordship, that part also I have flag marked. 3 note in like this CD. I think in the second part, lordship, maybe. It is in a horizontally, I have flag marked as note, if I remember.
He has stated that he may
Lordship.
throw away,
Yes,
he
Lordship.
may throw
Yes,
away, but
Lordship.
they are in custody.
Lordship, at that point of time, Lordship.
Then anybody will write this. What is the protection given by section 55? Section 55 is protection given for, so that the drugs may not be planted by the police officers. It says that language is when it is not possible to take. So he has to mention that impossibility, why it is not possible to take. You read section 55
Lordship.
when
Lordship, police to take search of articles seized and delivered.
section 50 clause 5 read.
Lordship, 55 or Lordship?
50 within bracket 5.
Oh, 55, yes, Lordship. When an officer duly authorized under section 42 has reason to believe that it is not possible to take the person to be searched to the nearest gazetted officer or magistrate without the possibility of the person to be searched parting with possession of any narcotic drug or psychotropic substance or controlled substance or article or document, he may, instead of taking such person to the nearest gazetted officer or magistrate, proceed to search the person as provided under section 100 of the Code of Criminal
So
Procedure.
if he has
1970.
reasons to believe,
Yes.
if he has reasons to believe that search cannot be made, search is impossible, that reason has to be mentioned. That reason has to be a separate reason. He cannot write in the CC case diary that I have reason to believe.
And 50 is important in this particular case because, my lord, neither in the FIR, one part, my lord.
Am I, make me more clear.
Lordship.
Whether in the case diary, is it sufficient to write that I have reasons to believe? Or that reason has to be mentioned? What is the reason?
Explanation of the reason.
Explanation of the reason. What is, that reason has to be described in the note. By mentioning that I have reasons to believe that that is not sufficient.
And even Gamusa part, my lord, is first time in the court. And he has, my lord.
Your submission is that he has mentioned a reason under
Yes,
55
yes, Lord.
in the case diary.
Yes, Lord.
And then within 72 hours, that has to be communicated to superior officers under 50
Subclause.
clause 6. Now 56 is whether it is mandatory or not.
50 otherwise is mandatory, my lord. And the first time in the court, my lord, he has stated in the cross, it is not mentioned in FIR. In my statement under 161 CRPC and the statement of seizure witnesses that the contrabands were concealed by the accused Ranjit Dowry in a gamusa and Ganesh Chandra Dowry in a sling bag. The first time in the court he has stated about all these things, my lord.
What he has stated for the first time?
That, my lord, the contrabands were concealed by accused Ranjit Dowry in a gamusa and Ganesh Chandra Dowry in a sling bag.
No, in the case diary also he has mentioned. In the case diary I has mentioned.
In the FIR and 161 statement and statement of seizure witnesses, my lord, as per cross examination.
Okay, make your complete your submission.
Lordship, that is my submission, Lordship. That, but I have already only that much 42 and this 50 part, Lordship. Because otherwise 42, if this after sunset, Lordship, definitely authorization is required.
Heard Mr. M.K. Das, Lanitz, counsel for the petitioner. Also heard Mr. K. Busher, London additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely number one, Shri Jirap Singh Devri alias Ranjit Devri, and number two, Shri Ganesh Chandra Devri, who are detained behind the bars since 7/6/2023 within bracket for last dash days. How many days they are behind the bars?
My lordship, August, 6th August, 14 months.
How many days have lapsed? 14 months
14 months, my lord.
for last
6th August.
14 months in connection with
Sorry.
NDPS case number 54/2023 arising out of Sadia PS case numbers 126/2023 registered under section 18 within bracket small b of the NDPS Act, 1985. The gist of accusation in this case is that on 6/6/2023, one Shri Jugal Deka, SI of Police of Sadia Police Station, lodged an FIR before the officer in charge of Sadia Police Station, inter alia, alleging that on receipt of an information through reliable sources that on 6 June 2023, one Shri Ranjit Devri and Shri Ganesh Chandra Devri within bracket present petitioners were in and around the area of Gorgaon carrying psychotropic substance for sale and consumption. Stop. Not stop, a general diary entry bearing GDE number 123/ dated 6/6/2023 was made, and thereafter a police team was dispatched to Gorgaon Village Road along with 3 witnesses, wherein the present petitioners, namely Rajit Devri and Ganesh Devri, were found. The informant gave them notice under section 50 of the NDPS Act for body search, but decided to search the body of the petitioners himself. As it was believed by the informant that the suspects would part with the possession of NDPS, will part with the possession of the contraband. Stop. During search operation, 3.320 kg of contraband suspected to be opium was recovered from one sling bag which was carried by one of the petitioner. There is no mention about Gamosa in the
Not
FIR.
mentioned. And 161 statement also.
Sling bag which was carried by the petitioner. On receipt of the said FIR, Sadia PS case number 126/2023 was registered and investigation was initiated. Stop. After completion of the investigation, ultimately the charge sheet was laid against both the above named petitioners under section 18 within brackets small b /29 of the NDPS Act, 1985. Learned counsel for the petitioner has submitted that Mr. M.K. Bora, learned counsel for the petitioner, has submitted that,
MK Das.
sorry, M.K. Das. In the instant case, there has been violation of the mandatory provisions of NDPS Act, mandatory provisions of section 42 and section 50 of the NDPS Act, 1985. It is submitted by learned next para. It is submitted by learned counsel for the petitioner that the informant, who is the search and seizure officer and who was at that point of time a probationary sub-inspector of police, was not authorized to conduct a search under section 42 of the NDPS Act, 1985. Stop. Learned counsel for the petitioner submits that this has been admitted by the informant himself while he was deposing as PW1 before the trial court, wherein he has categorically stated that he was not authorized. What he has stated, he was not authorized by
I was not given any written authority letter by the superior officer to go to the place of offense.
he has categorically stated that he was not given any written authority letter by any superior police officer to go to the place of occurrence for conducting search and seizure. Stop. Learned counsel for the petitioner has also submitted that in the instant case, there has been violation of section 50 of the NDPS Act, in as much as from the evidence of PW1 before the trial court, it appears, it becomes clear that some of the, how much quantity was from the sling bag? Quantity is mentioned.
Three 3.320 kg.
3.320 kg of the opium was recovered from the sling bag carried by petitioner number
2, my lord.
Petitioner number 2. From where you are reading?
My lord. The FIR, my lord. Ganesh Chandra Deuri. This third page of examination in chief, my lord. Third page.
Okay.
Thereafter, I searched the body of Ganesh Chandra Deuri, but nothing was recovered from his possession. The sling bag carried by Ganesh Chandra Deuri was searched by me, wherefrom I recovered kani kept inside a black color polythene bag. Then, my lord, the gamusa part.
Learned counsel for the appellant petitioner has also submitted that from the testimony of PW1, it is also clear that the informant also made personal search of Rajit Deuri from whose possession some amount of opium was found, which was tied in a knot of gamosa within inverted comma, wrapped around his waist. Learned counsel for the petitioner has submitted that, however, the informant had not complied with the mandate of Section 50 of the NDPS Act by informing the petitioners that they are entitled to be searched in presence of a magistrate. Or a gazetted officer. Stop. Learned counsel for the petitioner has submitted that as the punishment prescribed by the NDPS Act are stringent in nature, the procedure prescribed by the Act has to be scrupulously followed. And in case of any violation of the mandatory provisions, the accused are entitled to get benefit of the same, even at the stage of consideration of a bail application. In support of his submission, any other submission?
That is
In support
first
of
time in the court at Kamusa apartment.
learned counsel for the petitioner also submit
The petitioner one. FIR 169.
learned counsel for the petitioner has cited following rulings in support of submissions made by him. Number one, Raju Premji versus Customs NER Shillong Unit, reported in 2009, 16 SCC 496. Then Directorate of Revenue and others versus Mohammed Nisar Holia, reported in 2008, 2 SCC 370. Then number three, Mohammed Jabir versus State of NCT of Delhi, reported in 2023, 3 JCC 1497. Then Raghu alias Raghu Rajput Thakur versus State of Orissa, reported in 2023, 0 Criminal Law Journal 487. Thereafter,
2022 1 crimes.
thereafter, Sunil versus State of Haryana, reported in 2022, 1 crimes within bracket HC 270. So, on the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the above named petitioners on the ground that the quantity of contraband seized in this case is of commercial quantity, and therefore the embargo of section 37 of the NDPS Act, 1985 would be applicable to this case. He has also submitted that there has been due compliance of all the mandatory provisions of the NDPS Act in this case by the investigating authority.
And my lord, what my lord has queried regarding the notification,
It is
that
mentioned.
is mentioned in
I have
the
seen.
SR 17 laws. That is mentioned.
The learned counsel for the petitioner has also submitted that as the officer who conducted the search was an SI of police at the time when he conducted the search, he has been authorized by the notification issued by Government of Assam bearing number EX 145/85/290 dated 25/4/1995 under section 42 within bracket 1 of the NDPS Act, 1985. Hence, he submits that absence of a written authority letter would not vitiate the search in this case, as the officer who conducted the search was authorized by a notification issued by Government of Assam under section 42(1) of the NDPS Act, 1985. Moreover, he has also submitted that the search was conducted on 6th of June 2023, which is the month of summer when sun sets lately. And in this case, the process of conduct of search operation was initiated at 4.
Lordship, it is, I think, concluded, Lordship, that part.
Initiated at dash
Yes.
and was concluded at dash
45, my lord.
245,
2:45
they
PM.
received the information.
Initiated.
and concluded at
They received the information 245,
245.
but because 50 minutes.
hence he submits that dash लिखे रहने वो पिसद बढ़ा लिखे. Hence he submits that the search operation was conducted in the instant case after sunrise and before sunset, and therefore the proviso 2 of the section 42 of the NDPS Act is not applicable in this case. Stop. Learned counsel for the learned additional public prosecutor has also submitted that in the instant case, the personal search of the petitioners was conducted by the informant, conducted by the search and seizing officer under section 50 within bracket 5 of the NDPS Act. And reasons for conducting the said search by the informant himself without taking the petitioners to a gazetted officer or to any magistrate has been duly mentioned in the case diary. And have you informed the senior officers?
Lordship, that part, I have to go through. Yes, I also see all these 3 parts. Whether that 6 is.
Okay, you go through
56 part is there.
56.
Yes.
Because
Yes,
non-compliance
within
of
72 hours, that has to be informed. That has to be
because
informed.
that is also
That part I missed, Lordship, actually.
you go through that.
Yes.
I am mentioning that he has complied with,
Uh,
but you,
But I'm just, if you provide me, and within 2 minutes, I will.
learned
provide.
counsel,
If it is
learned
provided, then-
additional public prosecutor has also submitted that regarding compliance of the procedure prescribed under section 50 within bracket 6 ... I, officer, I have considered the submissions made by learned counsel for both the sides and have perused the materials on record, including the case diary, including the scanned copy of the case record of NDPS case number 54 within bracket H/2023, which is available on records. You go through that,
No, sir, right now.
not necessary right now. I'll
Yes.
deliver the orders
Yes, yes.
after I'll go through the records myself.
Lots.
Yeah, the separate orders, separate order लिखिबो. Right? Heard Mr. M.K. Das, learned counsel for the petitioner, also heard Mr. K.K. Bushaw, K. Bushaw, learned additional public prosecutor. Let this matter be listed for delivery of orders on 9th of August. 9th August I will deliver. 9th of August 2020.
Deeply obvious.
Not on 9th, my junior will be there, my daughter's son.
No, on that day I will only deliver it,
My
no
lord.
hearing.
My lord, my lord.
You see the record now?
Now, Lordship, it's because only I will.
On that day, only delivery part will be there at 10:30.
My lord, deeply
Deeply obliged.
Iman? Yes.
May I please your lordship? Lordship, service is complete, lordship, and LCR receipt fixed for hearing, lordship.
Heard Mr.
P. Sharma.
P. Sharma, learned counsel for the appellant. Also heard Mr.
R. Paul. Your lordship, I haven't received the copy of the IA 112.
What for IA is?
IA stay, lordship. Injunction.
You are not pressing that.
No, lordship, it is fixed for hearing.
I haven't received the copy, your lordship.
We will fix which for here, regular first appeal for hearing.
Yes, lordship.
Okay. Heard Mr.
R. Paul, on
R.
respondent
Paul,
number 6.
appearing for respondent number 6, as well as Mr.
Conmay Majumdar for 2, 3, 4 and 9.
T. Majumdar, appearing for respondent number 2, 3, 4 and 9. The service of notice as regards other respondents has already been completed. This case is ready for hearing. Registry to list this matter for hearing after 4 weeks on a date to be fixed by.
Lordship, they may be directed to
The-
serve the copy of the IA.
The appellant side, appellant shall furnish a copy of the interlocutory application filed by him to the learned counsel for the respondents, along with the annexures. Let this case be listed accordingly after 4 weeks.
Highly obliged.
As per order of this honorable court below, the name of the legal heirs under section number 4 has been included. Incorporated. So my prayer notice now may go on them. I raise them. And that you must find item 45, it's a IA number 45.
Which will be
that 7% legal years, those will.
Now we will take up IA number 45 only.
Fine, and that names have been mirrored, yes.
In
And
I, in
names
I,
have been incorporated,
IA number 45 is for condonation, okay.
298 days.
In IA number 45, that is item number, this is item number
42. And ISC number 45, only 24.
IA number 45, item number 42. Heard Mr. A. Rashid, learned counsel for the applicants. Also heard Mr.
My lord, I number only main respondent number for Lal Banu already died and subsequently.
You are not appearing for,
After notice.
I am the main case here.
okay.
Other case is there.
Notice maybe.
As per order dated 1/8/2024, passed in IA number 2178/2024. The legal heirs of respondent number 4 have been impleaded in this case. Issue notice to the respondents. The applicants shall take steps for issuance of notice to all the respondents by registered post with AD.
Preliminary, it will be all the legal years of the respondent 4. That will be for formula. All the legal years.
All the respondents as well as, no, legal year of respondent number 4 have been
Today and notice will go on them.
and to other respondents?
Others there are always there, my lord.
No, how? In this case, notice is not yet issued.
Notice, main case notices history was there, notices been issued, my lord. And there is a mail on finish appearing, my lord.
But main case has been. Why this IA? IA is for condonation of delay.
One person expired. Sorry. One person expired, and so there is a delay in filing the substitute petition. So this, my lord, I.
Oh, okay.
My lord, the respondent number for Lal Banu, the legal heir of the respondent number for Lal Banu legal heirs, 45 is the petition. That petition not including in the legal heir. Subsequently, earlier order, my lord, legal heir prayer is another IA writ petition 2178. On basis of 2178 already disposed, that legal heir included in the 45 IA petition, and notice may be issued on the condonation of delay, my lord. First time condone may be.
Condonation of delay notice will go to
the
whom? Only
legal-
to the legal heirs of,
respondent number 4.
or to other respondents also.
Others, no need.
Your lordship, 45 is the legal heir of condonation or my lord substitute petition? Condonation, my lord. Condonation and notice may be issued, my lord, 45.
To
Legal
whom?
heirs, legal heirs of
To the newly
respondent number for Lal Banu, my lord, maybe mention Lal Banu.
Legal years of respondent 4. Lal Banu. Who is your lordship, my lord, subsequently, my lord, allowed.
And Lal Banu, your lordship, Lal Banu, the legal heir of another IA petition is mentioned in the legal heir of Lal Banu, IA 2178.
No, but here you have made others also respondents.
No, only for the formal party will be there now. In
Whether
IA number,
notice
my
will
lord,
go,
two-
whether notice will go to Quddus Ali or not.
No, those will, they will not be.
Why?
Already they are there in the party, you know. Already they have come. While I am preparing for them, you know. Only now newly implemented party, you know, that is the legal years of respondent number 4. I have your lordship has mentioned the names. So now notice will go to them. For continuing,
45%.
for continuing the delay of the case. 298 days.
My lord, as per all the physics of the বাকিগুলো আপত্তি নাই, বাকিগুলো আপত্তি।
Okay, issue notice to the legal heirs of respondent number 4.
My lord, respondent number 4 barricade dot, my lord, maybe mentioned a Lal Banu. Or
that is mentioned.
in the original petition.
Respondent number 4, namely
Lal Banu.
Musammat Lal Bhanu Khatun. The petitioner shall take steps for issuance of notice to the said respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let this case be listed again after 4 weeks.
Most of.
Time khatam.
Lordship, my item is 47. For order, because of this MSCP appeal, there is a delay condemnation petition, my lord. Whether your lordship will take up today or fix a date.
Issue notice.
Yes.
Condemnation 47 issue notice returnable after 4 weeks.
Yes.
Within 7 days.
I'll take steps within 7 days.
Take steps within 7 days. Heard Mr. R. Goswami, learned counsel for the appellant. You are appearing for?
Let's see, note.
Okay.
No respondents.
Issue notice.
Obliged, my lord. I'm obliged.
Issue notice to the respondent.
Your
Yes.
lordship, item number 43. The next item.
Yes,
Your lordship, in this case, there is a delay of only 70 days.
but it is being contested.
Your lordship, they have challenged only the quantum, and my prayer is that delay may be condoned and appeal may be numbered and listed before the upcoming Lok Adalat.
You are conceding.
We are
Insurance is the appellant, I am the claimant.
Who has filed the delay application?
Insurance. company. I have no objection if the delay is condoned.
43 Diok.
And already negotiation is going on, so it will be.
Heard Mr. A. N. Das, learned counsel for the applicant. Also heard Mr. D. Mondal, learned counsel for respondent number 1. This application under section 5 of the Limitation Act. It is actually not Limitation Act. It should be proviso
173
to-
subsection 1,
Yes.
read with section 5 of the limit.
Section 5 of the Limitation Act 1963 for condonation of delay of 70 days for filing the connected appeal against the judgment and award dated 23/8/2023 passed by the Motor Accident Claims Tribunal Nagaon in MSC case number 47/2020. Learned counsel for the respondent claimant.
Respondent number 1.
Respondent number 1.
1.
Respondent number 1 claimant has not opposed the prayer for condonation of delay. Considering the concession made by learned counsel for the respondent number 1, as well as considering the considering the reasons shown in the delay condonation application for filing the appeal after a delay of 70 days, this court is satisfied that the applicant has sufficiently explained the cause of delay in filing the connected appeal after lapse of 70 days beyond the limitation period. Hence, the delay of 70 days in filing the connected appeal is hereby condoned. And this interlocutory application is accordingly disposed of. The registry to register the connected MSc appeal and list the same after a week.
No, your lordship list the same before the upcoming Lok Adalat.
When?
In September.
September. 14
List the,
September. 14 September.
list the same before the next ensuing Lok Adalat, as both the parties have prayed for listing the matter before the Lok Adalat. Stop.
Highly obliged.
My lord, item number 4951, my lord, first time, my lord, notice may issue, my lord.
14 and 51.
Yes, my lord.
Item number?
49 and 51.
This is delay condonation.
Yes, my lord, for the first time, my lord.
Ito Abhishek Eken is now heard Miss L. Sharma. L. Sharma. Issue notice. L. Sharma learned counsel for the applicant. Issue notice to the opposite parties. The applicant shall take steps for issuance of notice to the opposite parties within a period of 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Please, your lordship. My lord, I wish to mention item number 54, your lordship. There is a delay of 334 days, your lordship, in filing the appeal, your lordship. So, my lord, in that case, it's,
Heard Mr. A. Diwan in interlocutory application. Heard Mr. A. Diwan learned counsel for the applicant. Issue notice to the opposite parties. The applicant shall take steps for issuance of notice by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
lordship may be on the 10 days, your lordship, because some difficulty.
10 days.
10 days.
Instead of 7 days, it's 10 days of the date of this.
Please, Lordship, item number 45, similar, where there is a delay condonation petition of condoning the delay of 18 days, my lordship.
Item number
45.
45, same order. Heard Miss, what is your name?
M. Sahu.
M.
Sahu.
Sahu. M. Sahu. Learned counsel for the applicant. Baki Eke order. After 4 weeks, within 7 days, weeks.
Oblige, your lordship.
My lord, I have Ramchandra saying that intimation is available.
Yeah.
I have flagged it.
Flagged it.
Flagged it, lords, within the same.